said I wanted to try to do this in 4 videos, and I think I did it. Last video, Fifth Amendment, the accused. So this protects people, not entities. So not corporations, not just people, not estates. All right, the rule is persons may not be compelled to testify against themselves in a criminal proceeding. The right is personal and cannot be claimed on behalf of others. This is not the same as the privilege afforded to some parties, that like privileges like spousal privileges, but it acts in a comparable manner. The right is only to testimony. It's not for compelled disclosures like looks, fingerprints, DNA. So those are not included. Although fingerprints on a phone are considered by the court as to be testimonial, which Mcgoldrick is like, no. A signature is not testimonial. Being drunk is not testimonial. Voluntarily prepared documents are not protected by the Fifth Amendment, but the fact of producing them might be. So this would only be true of docs that are inherently incriminating, like if you made a second set of books. If compulsion occurs, there might be criminal or civil penalties as well as other significant losses if someone is compelled to testify. Only applies to criminal cases or civil cases that could later be used criminally. Compulsion could be like threatening to fire someone, so like in the Rodney King beatings, although that was found in went a different way, but or like an excessive force case where they were like, if you don't testify, we will fire you. That's compulsion. In a criminal court, you assert this right by just not taking the stand. And in a civil court, you will have to take the stand, but then that's when you say, like, I plead the Fifth. And then the Griffin rule is that the prosecutor cannot comment on the defendant not testifying. In fact, usually there is a jury instruction that explains it. If the defendant puts their mental status into question, the prosecutor can test it with their own witnesses. Okay. They find that testimonial, I think. All right, Miranda, another part of the Fifth Amendment. This only applies to custodial interrogations, and we're going to define custodial and interrogations, but this specifically does not apply to a stop. If Miranda is given twice, it must be given completely correct at least once. It cannot be like, well, A plus B equal. No, it has to be given once fully correctly. Additional Miranda elements are fine. They can be claimed at any time during the interrogation. Claim of Miranda is personal. An attorney cannot waive them for you. So you have the right to remain silent. You have anything you say or do can be held against you. You have a right to an attorney. If you cannot afford one, one will be given to you. All right, so what is custodial? Because anytime you're in custody, it's inherently coercive, is what we think. And after an arrest or equivalent to arrest, this means not a stop. So undercover cellmates are not considered custodial interrogation because you don't know that they are holding you. Stops are not custodial. Questioning in a police station will usually be considered custodial, but if it's like, well, we could do it here, or we could go to McDonald's, or we could go to the police station, you go, well, I'd rather just like go to the police station, it's right next door, then that's probably not going to be. But a questioning by your own parole officer is not going to be custodial. Then you have interrogation. So custodial interrogation, direct questioning, and the functional equivalent. So what a reasonable officer should know would lead to incriminating statements. That's interrogation. Questioning in custody by undercover officer is not considered a custodial interrogation. It's not coercive for an arrestee to think he's talking to a fellow dirtbag. I think that is the particular term is dirtbag. Routine booking questions are not interrogation. Confessions rule. Confessions obtained involuntarily by police coercion are not admissible for any purpose. direct or impeachment. Miranda confessions rule. Even voluntary confessions are not admissible unless Miranda rights have been satisfied. The logic is custodial interrogations are inherently coercive, and they are so much so that they would violate Fifth Amendment rights unless warnings are given to lessen the degree of coercion. Here's the caveat: confessions obtained in violation of Miranda can be used to impeach if the defendant takes the stand. We're going to ask that question because I don't know why I have both. All right, violations. Exclude and illegally obtained statements. Okay, so the statements are not in, but if I say, I killed this person and I put this where I put their body, they can act on that information. And if they find the body, that can be used. So there's no fruit of the poisonous tree consequences. They just can't say, well, like she told me where it was. They can just, but if you didn't give me good Miranda and you didn't know, and then later you're like, oh crap, then you can give it to me again and then have me repeat my statement and not tell me that the first one would have to be out. So only possible out in that situation is if you had intentionally given them to me wrong in the beginning. Because, like, you didn't want me to know that I had the right to an attorney, and then, like, as soon as I heard that, I was like, lawyer! So, Miranda may be waived. Waivers must be knowing and voluntary. You were given your rights, you understood them, which means, like, you spoke the same language, you were of sufficient intelligence, and you had knowing awareness of the vocabulary, and then you talked. Talking is waiver. And waiver cannot be obtained by trick. That violates Miranda, but not due process. The burden is on the prosecution to show waiver. You can knowingly waive rights without fully understanding the consequences of what you're doing. That's fine too. Waiving Miranda for one crime waives them for all and any, and the police do not have to specify at all what they are questioning you about or what they're giving you Miranda rights for. Claiming Miranda can only be claimed after custodial interrogation, so if you claim it before, it won't stick. You have the right to remain silent, cannot be used against you after Miranda, but it can be used against you before if you choose not to speak. Right to remain silent must be affirmatively claimed. When claimed, all questioning must immediately cease. But after a cooling off period, 2 hours, it may be resumed. After they give you the warning again. So you have another chance to waive. If waived again, they can repeat it one more time, and after that, they can't question you. A cooling off period may not be found, like if left in the room with the timeline of the crime, they're going to say, like, that wasn't cooling off. Okay, so when you claim your right to an attorney, all questioning must immediately stop. They cannot ask you about waiver. Out of custody, so if you then get let go, they cannot question you again for 14 days without an attorney, not even to ask about waiver. But in custody, asking for an attorney remains indefinitely for the crime accused of. However, some cases say that when you are in custody home, it could be your cell, which could constitute a cooling off period. Claiming Miranda applies to all crimes, not just the one that you were arrested for, but your ask must be unambiguous. So you can't be like, maybe I should have a lawyer? Not gonna work. If suspect initiates talking, the attorney ask no longer applies. So if they asked for one, but then they start talking, like, that's fine. A violation is no fruit of the poisonous tree. Which I think is like out, but info is in. Unless it's purposely, and if warnings are purposefully ineffective, all subsequent statements will also be out. Bad faith. All right, double jeopardy. A person cannot be tried for the same crime twice. They cannot be twice put in jeopardy. And the prosecution cannot appeal a wrongful acquittal. Difficulty is defining same offenses. The greater includes the lesser, and the lesser includes the greater. The Block-Berger test say crimes of the same offense are the same offense unless each has a distinct element. Double jeopardy does not preclude trials from different jurisdictions, so like state and federal, or even 2 different states. You can be tried in different jurisdictions. Jeopardy attaches at the impaneling of a jury or on bench trials when the first witness is sworn in. Does not attach to mistrials, hung juries, dismissals not made on the merits of the case, an overturned verdict on appeal that may be retried. But if the overturn was based on insufficiency of the evidence, they're not going to be able to be retried. Though that almost never happens. Overturned conviction. Okay, if jury finds murder and manslaughter, he can only be sentenced for 1. Multiple violates double jeopardy. Our last topic, 6th Amendment. Yes. All right, 6th Amendment is also questioning, but 6th Amendment means you've now been formally charged. Once formally charged, there is an automatic right to an attorney, absent waiver. So it's not Miranda. You automatically have it. They cannot question you about anything, period, end of the story, except for waiver. And they get waiver by giving you Miranda. And then you either waive it or you don't. Which is super sketchy because most people would have no idea that they cannot question you without an attorney present. And that is shady. So much not okay. Anyway, this applies to all questioning, not just custodial, but it's all questioning about the charged crime. So if it's other crimes, not the case. Charged crime, that's it. Okay, so an undercover cellmate does not apply, although I think it does. So I have that question from Mcgoldrick. Questions can be asked about uncharged crimes, however. Intentional attaining of incriminating information. So if someone's just like saying stuff around you to get you to snap, that's going to be intentional getting you to talk, and that's not going to be allowed, even though they're like, I didn't ask a question. The suspect can be asked about waiver without an attorney being present. They do this by giving Miranda and ask if you want to waive, which is different than Miranda because they cannot ask if you want to waive it. Once you claim a lawyer, they cannot ask you to waive it. And once you just remain silent, they can't ask you again for 2 hours. So, scope of rule. Absent waiver, an attorney is required for all felonies or for all misdemeanors where the sentence after conviction involves actual incarceration. So if they're not going for that, then they don't have to give you an attorney. But they have to know that before, whether jail is going to be on the table or not. The fruit of the poisonous tree doctrine is undecided in this case. So here are some sticky situations. Confidential informant is told not to question, but he does anyway. That stuff is out. He's considered to work for the police. They're like, it's your fault, police. You put him in the situation. It's out. But if a confidential informant said, don't ask questions, just listen, And then the guy's like talking about his plan, and he's like, I don't think that's gonna work. The court says that's active listening, and that's okay because that's what people do. And if he just stood there silently, like, that would maybe blow his cover. And then police ask about other info and get information of the charged offense. And the court's like, nope, you were asking about other info. You got to, nope, that's out. It's not going to be allowed. And then a lawyer is also required if there is an in-person eyewitness identification. And this is going to be, so there's going to be Sixth Amendment issues and due process issues. So the Sixth Amendment issue is any person formally charged must have an attorney present during any lineup or other in-person ID for a charged crime. Violations are per se excluded as evidence, so that identification will be out. But the person who is IDing when there was a violation is allowed to testify in court and make the ID in person in court. If you can prove that their ID came from witnessing the crime and not the faulty ID procedure. My husband's about to come in the room, and I'm doing this video, so I can't talk to him right now. So then we have, so that's Sixth Amendment issues. They can still come. Then we have due process, which is reliability rule. So even if a procedure was unfair, it will only be a violation and out if it was unreliable, and that's Braithwaite rule. It's only going to be out if the police were reasonable, it's only going to be out if the police were responsible for the unfairness. So the opportunity to view, the degree of attention, the accuracy of the description, the witness certainty, times between crime and ID, that's going to show us reliability. So it's going to be in if it's still reliable. It's going to be out if it's unreliable. And that's based on how long did they see the person? What was their degree of attention? Was there a gun in their face? Because there's like barrel of a gun issues. Accuracy of description. Did they say the guy was white and now you're saying the guy's black? Like, that's not going to work. Witness certainty. Like, did they say no to 5,000 people and then all of a sudden they saw your client 6 months later and they're like, that's him. That's pretty certain. And then time between crime and ID. Was it like, hey, this just happened to me and then I saw him like 30 minutes later. Statements obtained by coercion violate due process. Psychological pressure is not coercion. Trickery is not coercion, but limited precedent, fake creation of false documents indicating proof of guilt might be a violation. And then suggestive procedure rule must be tested for reliability before ID is admissible. So if it's a suggested procedure, they're going to say, like, how reliable is it? If unreliable, then the ID is going to say not admissible. You don't have a right to an attorney for a picture lineup because it's not in person. Okay. Jury trial. A jury trial is required for all felonies and all but petty offenses. A petty offense is anything with a sentence of less than 6 months. And then you have speedy trial. Okay, so Sixth Amendment right to an attorney is anything that could result in prison. But jury is anything above 6 months. Speedy trial. It begins at the point of arrest or formal charge, whichever occurs first. Prevents detention before being found to have committed a crime, which prevents anxiety and the harm that hangs over someone's head with the threat of jail. The longer a trial is delayed, the harder it is to make a case. And then here's the timing rule. There's no precise time frame, but violations are determined by balancing factors, and those factors trigger at about the year mark. So they're going to look at the length of the delay. The reason for the delay is the defendant's assertion of rights and the prejudice to defendant for the delay. So the length over a year is going to be concerning. The reasons for delay, there's going to be differing weights for different reasons. If the wait was because of the prosecution, that's bad. If it's because of the defense, that's going to be like, well, okay. How long was the wait between the defendant's assertion of the right And then, if it's been 6 years, but the defendant only knew about it for the last 3 months, it's not going to be that big. And then the prejudice of the delay, because the delay can use loss of exonerating or exculpatory evidence, but it could also be the prosecution's evidence, so that could be weighed. Were they incarcerated beforehand? Because that's an issue. And then, like, the anxiety, how long did they know about this? Again, if it's been 6 years, but they only knew for 3 months, they were never incarcerated, then it's probably not a big deal. But if there is a violation, the case is dismissed and cannot be retried. And then so we have due process versus speedy trial, and due process protects against a bad faith delay, and that is between the crime before arrest or the formal charge. And I actually had an appeal that they didn't choose, so I had to write about both. But sometimes this is kept in check through a statute of limitations anyway. So, but then waiting for a reasonable doubt instead of probable cause is not bad faith, because in order to win a trial, you need to be beyond a reasonable doubt, which is significantly higher than probable cause. So some people don't want to bring it yet until they've got enough to actually try the case. But like bad faith would be like, hey, we were waiting for his alibi to die. That would be bad faith. And then last but not least, which won't be on the test, he said, but he did tell us because it's on some old exams, is Brady. And that's when that means prosecutors must turn over to the defense any substantial exculpatory evidence. And if they don't, it's a Brady violation. And then we look if there was prejudice because of it, which is super hard to find, even when it's